Usually we talk about the Second Amendment, but today I want to talk about January 6th for one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, and best-selling author. If you haven't subscribed to the Four Boxes Diner YouTube channel, please do so and show your love for the right to keep and bear arms. Okay folks, I just want to talk briefly about an observation that I think we should all be aware of involving the January 6th events. I'm no expert on January 6th or the Electoral Count Act or anything like that, but I do have an important observation that I think we should all remember, and I think has been lost. And that's this. The argument at the end of the day was a legal argument about how do you count electoral votes from the states that were submitted to the United States Congress at an event on January 6th, at essentially a meeting of Congress on January 6th, whereby Vice President Mike Pence presided over the counting of the electoral votes. Obviously, he who gets the most electoral votes, assuming he reaches a certain threshold, is the next president of the United States. We had a big fight about it in 2020 between Donald Trump and Joe Biden. We know all those basic facts. But here's my observation. Again, I'm no expert on January 6th or the Electoral Count Act. What is the Electoral Count Act, though? This is very important to understand. The way the president is selected is through electoral votes assigned by the various states. Every state has electoral votes. They give them to Congress, and Congress counts them. It's effectively how it works. The way this goes down is under a federal statute from the late 19th century called the Electoral Count Act. The Electoral Count Act. In it, it describes the various processes by which this occurs. Now, here's my only observation. Many people seem to be saying that President Trump's legal position was frivolous, that it was wrong, that Mike Pence had no say as to how to count the electoral votes. He was there basically just ceremonial, as a ceremonial VIP overseeing the process. And maybe that's true, but maybe it's not. And here's why I say that. You see, over the last few weeks, this is what's got me thinking. I've noticed all these news reports about how there's a bipartisan group of congressmen and senators that want to amend the Electoral Count Act. And I was thinking, like, why do they want to amend the Electoral Count Act? Well, it turns out that, I've looked at the news reports, they want to amend the Electoral Count Act because they claim the Electoral Count Act is ambiguous and vague. Let me give you a couple examples. NBC News reported that a bipartisan group of senators agreed to changes clarifying the vice president's role in certifying the Electoral College. Clarifying. CNN reported, as part of the proposal, senators are attempting to clarify that the vice president only has a ceremonial role in overseeing the certification of electoral results. New York Magazine referred to the Electoral Count Act as confusing and outmoded, and that ambiguities in the law, after all, allowed for the January 6th chaos in Congress, etc., etc. So here's my question. So all these people are calling the Electoral Count Act vague and ambiguous. Okay. Well, what does vague and ambiguous mean? It actually has a particular meaning in the law and even beyond. And that is that a particular word, a particular sentence, a particular document, whatever it is, if it's vague and ambiguous, it means that that language is subject to multiple reasonable interpretations. Many of times they can be contradictory. So if something is subject to multiple reasonable interpretations, it's vague and ambiguous. Let me give you a classic law school example. We talk about this in law school when we train young lawyers. It goes like this. If you're in a courtroom and somebody asks a witness the following question, "Sir, when was the last time you beat your wife?" Objection, you would hear. Why is the question, "Sir, when was the last time you beat your wife?" Objectionable. It's because it's vague and ambiguous. How so? Because that sentence could refer to the witness beating his wife, right, at tennis. It could refer to beating his wife physically. It could refer to beating his wife at checkers. We don't know. And that's why it's vague and ambiguous, because that question is subject to multiple reasonable interpretations and multiple meanings. So it's vague and ambiguous. So take that example back to the Electoral Count Act. why is these people saying that the Electoral Count Act is vague and ambiguous and needs to be clarified today in 2022? So if all these people are saying that the Electoral Count Act in 2022 is vague and ambiguous, subject to multiple interpretations about the role of Vice President Pence or the Vice President in determining whether or not to certify an election and electoral votes from various states, if it's vague and ambiguous onto that question, well, that is basically an admission, a concession, an acknowledgement that in January 6th of 2021, the same exact Electoral Count Act that's vague and ambiguous today, subject to multiple interpretations of the role about the vice president, it would also be vague and ambiguous and subject to multiple interpretations as to what the vice president's role was on January 6, 2021. Now, whatever the best argument is, it's not for me to say. And I'm not going to become an expert in the election of 1800 or the Electoral Count Act or any of these things. That's not what I do, and I'm not that interested in it at the end of the day. But I will say this. Anyone that suggests that the Trump position legally had no merit, the question I would ask is, well, if it had no legal merit, then why do these bipartisan group of congressmen and senators feel the need to clarify the Electoral Count Act if it's so clear that the Trump position was absurd? Let me give you an example of what would be absurd. The U.S. Constitution provides that Senate terms for a senator are 6 years. It says 6 years, 6 years. So if you come up to me and says, a U.S. senator can serve one term of 22 years, I'd be like, no, it's clear and unambiguous in the U.S. Constitution that a Senate term is 6 years. Or if you came up to me and says, well, the presidential term is really 6.5 years, I'd be like, no, that's absurd. The Constitution clearly and unambiguously says it's 4 years. 4 years, clear, no debate, no ambiguity, no vagueness. You don't need to amend it. It's 4 years. Those are examples of things that are clearly black and white. But apparently the Electoral Count Act, which is the subject to all this controversy on January 6th of 2021, apparently there's a bipartisan group of senators and congressmen, and congresswomen presumably, who don't think the Electoral Count Act was clear and unambiguous, suggesting, of course, that there were room for multiple interpretations of the law. Just something to think about as you move forward and read the papers and reflect on our government. Okay, folks, I hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. And remember, we'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.